Natural justice. Orisha Mawar. Jinghui. Nadra. Abirami. Min Min. Priyatharizeni. Salsabila. Christina. Isha. Celeste, Christy. What is natural justice?
The nature of natural justice is that it is a procedural safeguard against improper exercise of power by a public authority. It has formed an important component of element in administrative law. A concept stressed mostly on procedural fairness. Under this concept, the affected party has a right to be heard. It is also known as right of hearing. Apart from that, there should not be any element of bias on the part of the decision maker.
So what is ultra-patum? In ultra-patum, a reasonable chance to present his or her case. It implies that no one should be condemned without being heard and that he has a right to be informed of the charges brought upon him. In Audi Arpatum also stated that a person has a right to be given a fair chance to present all pertinent defense evidence. In many statutes, usually provisions are made ensuring that a notice is given to the person against whom an order is likely to be passed before a decision is taken. However, some statutes may not contain such provisions. So, this is when natural justice takes place, which is when audi actions apply. Because natural justice operates in areas where there are no laws. Thus, these values support the law and guides against injustice. Okay, students, one of the example of case that violated natural justice can be seen in the case of Artik Kainak against General Manager Indian Oil Corporation 2005. The citation is 7 SCC 764. In this case, it was held that non-observance of principles of natural justice reshapes the order. Only when some real prejudice is caused to the claimant by such omission. Now the said principles are applied, having regard to the facts and circumstances in each case. Where the inquiry officer found one of the charges not proved here, and without issuing a show cause notice, the disciplinary authority found even that charge to be proved, court held that the rules of natural justice were definitely violated in this case, causing prejudice to the delinquent.
Hi, my name is Nur Azana Arsha and I will be relating the case of Nagar Palika Nator versus UP Public Services Tribunal with Audi Altrampatam, which is a principle in natural justice. In this case, the plaintiff were reminded to give a reply in the charge sheet and to meet the inquiry officer. Thus, it cannot be said that the right to be heard were not given to him. Okay, so does anyone else have any other questions? Please stand up. Yes? Okay, so in the case of Syndicate Bank versus Venkatesh Gururao Kuraji, 2006, they were given right to be heard. This is because the inquiry officer did not referred to the non-supply of documents during the course of inquiry. Thus, it shows that there were no prejudice done to the delinquent officer. Okay, so this is similar and relates to the case of Chatterjee versus Jogadut, where although there were a personal judgment, they were not deprived of the right to be heard.
Principle to Nemo Judex. Definition. Application.
Nemo Judex in Kosaswa literally means no one is a judge in his own cause. This maxim is also popularly known as the rule against bias. The importance of this maxim can be answered by Jeremy Frank, which is the author of the book Law and the Modern Mind, where no person can be free from various biases, political, religious, racial, economic, or otherwise. Now we are in fact brought up with a large number of biases. Education, religion, mass media, films, and literature nurture biases with the consequence that every person's mind is educated with biases of various sorts. So we must accept that it is almost impossible to have a mind free from biases. In sum, we should not judge our cause to prevent all bias from occurring. Now, the usage of maxim of Nemo Judex in Kosaswa could be divided into two situations, which are the existence of pecuniary interest on part of the adjudicator or non-pecuniary interest on the part of the adjudicator. Now, pecuniary interest meant that the adjudicator is having a financial interest in the outcome of the proceedings, whereas a simple financial interest would disqualify the adjudicator from hearing the proceedings. For the non-pecuniary interest of the adjudicator, it has to be validated according to the matter and give rise to the test of real possibility or real danger of bias.
Application of Nemo Judex principle.
The application of the Nemo Judex principle was first seen in R versus Sussex Justices, where it has established the precedence that a decision could be overturned by the mere appearance of bias, where judges could be recused for their lack of impartiality. Generally, in the past, there were two different tests being applied by different English authorities in order to determine whether there was a real danger or likelihood of bias, which was the reasonable suspicion of bias test and the real likelihood of bias test. In the end, the conflict between these two tests were resolved by the House of Lords in R versus Gulf, when the House applied the real danger of bias test. Using this test, the court should ask itself whether there was a real danger of bias on the member of the tribunal in the sense that he might unfairly regard with favor or disfavor a party after considering the case circumstances, and it is unnecessary to require the court looking at the matter through the eyes of a reasonable man, because the court will already personify the reasonable man. However, 8 years later, the House of Lords in Porter vs. McGill adjusted the test and laid down that the court must first ascertain all the circumstances which suggested that the judge was biased, and then only ask whether those circumstances would lead a fair-minded and informed observer to conclude that there was a real possibility of a real danger that the tribunal was biased. Today in Malaysia, courts are still applying the test laid down in R versus Gulf, which is the real danger of bias test. It was first applied during 1999 in a federal court case, and after that, cases even at year 2021 are still using the test due to the principle of stare decisis. Anyway, Judge Abdul Hamid's opinion in Dato Tan Cheng Chew vs. Tan Kim Hor during 2006 is rather notable, where the judge do not think that the real danger test will lead to an injustice or that the McGill test will lead to more justice, as what is more important is the integrity and the honesty of the judges themselves.
Issue number 1. Student disciplinary procedure.
Let's look at the case of Metropolitan Properties Company v. Lennon, whereby a block of flats belonged to a company. A tenant in a flat applied to fix a fair rent. The matter reached the Rent Assessment Committee, of which Lennon, a solicitor, was the chairman. Lennon lived with his father, who was a tenant in a flat owned by a company, as associate company belonging to the Sums Group as the company, which was now the party in the matter before Lennon. Lennon had assisted his father and others tenants in the fixing of fair rent for their flats. The decision of the assessment committee was challenged on the ground of Lennon's bias. Adaptation video of the case.
Adaptations begins. Christy is a 55-year-old woman. She lives in an apartment owned by Metropolitan Properties. Christy pays 500 ringgit per month. The black is Christy's daughter, Celeste. She is a high-demand solicitor and acting chairman to Metropolitan Properties. Green is Christina. She is Christy's much younger neighbor. Christina pays double the price of Christy, totaling at 1,000 per month.
Disagree with the increment of the rent. Some of the tenants applied to the rent officer to register a fair rent under the Rent Act 1965 and it was approved. The petitioner alleged that it was a biased decision as Celeste was assisting and advising Christy in this matter. Aggrieved, the petitioner took the case to the Divisional Court and made a complaint against Celeste.
From this case, it was ruled unbiased. In order to prove there was an act of bias, or in legal maxim called nemo judex in causa sua, Lord Denning emphasized that the absence of any appearance of partiality and deemed it unnecessary to inquire if the respondent was biased, given that reasonable people may assume he was. The simplest explanation is that justice must be founded on confidence, and confidence erodes when right-minded people have a slight chance of thinking that the judge was biased. Edmund Davies added that when real likelihood and reasonable suspicion tests are conflicting, real likelihood must be favored. Since justice should not only be done, but also be obviously seen to be done, it is never in the public's best interest to soften the conditions under which the public may conclude that there was bias. Thus, the court referring to the cases applied the test of reasonable likelihood as the test of reasonable suspicion felt, and ruled that despite the fact that there is no direct pecuniary interest or bias could be proven, still Mrs. Sladen should not have sat on the committee and the decision was overturned.
Issue number 2, unfair dismissal.
Hi Sal, I actually have a problem and I'm very lost right now. You see, I've been working at this one company for over 2 months when I was suddenly terminated for poor performance. But the problem is, my boss keeps ignoring my request for clarifications.
Seriously, that happened? It seems very short. They didn't really give any prior notice to you?
No, I myself was just called for an urgent meeting this morning. Turns out, I was fired right then and there without any proper justification.
See, it seems like an unfair dismissal case. In Malaysia, we actually have a lot of this case, and my firm actually handled quite a couple of cases of unfair dismissal.
I was just starting out my career and now this happened. You mentioned about unfair dismissal. Could you please elaborate more on that?
Yes, don't worry, we have it all. I will show you some of the law that governs. Okay, as you can see, in Section 14, Subsection 1 of the Employment Act 1955 requires a domestic inquiry to be held for employees covered by the EA before an employee carries out any disciplinary actions. We also have Section 20, Subsection 1 of the Malaysia Industrial Relations Act. Basically, these statutes govern that no employee can dismiss their employees without excuse or just cause. Under these provisions, the very first principle of natural justice is implied, which is the right to be heard, which in your case is not provided. Okay, this principle also laid down under Article 135, Subsection 1 and 135, Subsection 2 of the Federal Constitution.
Oh yeah, I came across this before, I think. If I'm not mistaken, Article 135 Subsection 1 mentioned about procedural protection for dismissal or demotion of rank of public service. Even though civil servants have no security of tenure, they can be removed, but only after prescribed procedures. But what about Article 135 Subsection 2? I'm quite unsure about this.
Yes, you got that right, Ms. Najra. As you can see, Article 135 Subsection 2, it is basically denoted that no public servant may be dismissed or denoted in rank without being given a reasonable opportunity of being heard. The statute is derived from the common law principles of natural justice. Natural justice consists of two important principles, which is the right to be heard, and second, the rule against bias.
I understand this now. So looking back at my situation, I think my right as an employee had no doubt been stripped off by the company by their unfair procedure. Not only there were no warnings or notions of underperformance, I was not even given the room for justification to improve myself.
Yes. Don't worry, and I will introduce you to my senior colleague, Miss Isha. She has a better understanding about this because she is the one who handles all cases about unfair dismissal in our firm. So don't worry, and I will introduce you to her. Let's follow.
Alright, thank you so much for your help. I will meet Miss Isha as suggested.
Now, Miss Nadra meets Miss Isha.
Hi, Miss Nadra, taxi.
Good day to you, Miss Isha. I'm Nadra, and Lisa suggests that I refer to you about my unfair dismissal case.
Nice to meet you, Miss Nadra. Yes, you had contacted me just now and I have been informed. From my point of view, every employee has the right to be heard before any action taken upon them. You, as an employee, have the right to let your employer hear your side of the story. One of the standards is that the person concerned must be given a fair and reasonable opportunity to defend himself. It means that no man should be condemned unheard and he has the right to know the accusation leveled against him.
Indeed, Miss Isha, I was not given the opportunity to speak up from my side of view. Could you throw light on this issue and perhaps for any subsequent steps that I can take?
Perhaps you could ask for an oral hearing or emphasize the need for the clarification under the principle of audi alteram partem, which means let the other side be heard. As in your scenario, I will show you this case. A dismissed employee should be given adequate notice within a reasonable time and a fair hearing. Right to the oral hearing has also been mentioned in the case of Vijaya Rao and Lelaki Supermaniam against Suruhanjaya Perkhidmatan Awam Malaysia, where the federal court took the view that the law as currently adopted by the court is more inclined in favour of affording a right to be heard orally to an officer facing disciplinary proceeding if there is a request made by him to the disciplinary authority. May I know if there is a slightly mention of the reason you were dismissed?
Well, there was a mention of poor performance. However, my employer ignored me when I asked for further clarifications. Perhaps I have failed to meet their expectations for the last 2 months of my employment. Despite that, I felt that this termination has been quite unfair for me, as I was a new worker in that company.
I see. Seems like your situation is similar to the case of Rahimi Yusof against Alpha Family Marketing. The industrial court held that the claimant's termination was done with just cause and excuse. The High Court questioned the decision of the industrial court and held that it is observed that the claimant was dismissed without any warning and was working with MP just for 10 weeks only. It was too early to say that the claimant failed to generate the business during that period. So I think for your case, you can seek remedies for what happened. You may seek for remedies which you can ask the first one is reinstatement to your former position in the company. The second one, if the reinstatement is not possible, then compensation in lieu of reinstatement.
Oh, I see. Thank you so much, Ms. Isha, for your guidance. I will definitely look more into this case as a reference for claiming my remedy.
I wish you good luck. Unfair dismissal cases have been a steadily increasing issue among working communities. This is where natural justice comes into action by ensuring everyone has a right to be heard. It is important to note that employees do have a right to dismiss bad employees, however, it must be done by the proper procedure.
The concept of natural justice still remains difficult to define, but for good reason. As no two cases are alike, it would be more of a disservice than an advantage to have the parameters of natural justice so tightly construed. Justice is an ideal which cannot be attained without following due course in every action. Thus, every judicial authority shall adopt such practice and arrive at such decision which is fair, just and reasonable. Alright, that's all from us. Thank you for listening.